The attorneys that change the way that real estate agents get compensated are asking for $82 million. Let's investigate. What's this about? All right, Sitzer Burnett plaintiffs' attorneys ask for a third of the settlement payout. Well, there we go. We knew that it was going to be roughly this amount, but you're going to see exactly how it gets broken down. After 5 years and nearly 100,000 hours of work, the law firms, there's three main ones, are asking a federal court for $82 million of the proposed settlements to be paid by Anywhere, Keller Williams, and RE/MAX. Let me know what you think down below because we're going to investigate a little bit further. Now, before I forget, this article is courtesy of Inman.com. All right, so let's see what we've got going on here. The attorneys who won settlements from major real estate franchisors, Anywhere, Keller Williams, and RE/MAX in the Antitrust Commission suits known as Sitzer, Burnett, and Morrell are asking a federal court for a hefty sum for their trouble. $82 million. Now, just as a quick little recap, we understand that the first major the suit that actually got class action status was Sitzer Burnett, and it named 5 parties to it. So it had Anywhere, Keller Williams, RE/MAX. Now they settled out. Well, 2 of them settled out before it actually got adjudicated, before it actually went into trial itself. That was Anywhere and RE/MAX. They settled before they actually got to the trial. And Keller Williams settled after the battle had been lost. Now there's 2, so they have already settled out, and you're going to see that's where we get the number that we're talking about today, or a portion of it. There's 2 entities right now that are still in this particular suit that are seeking appeals, and that's NAR and it's Home Services of America. So just to catch everybody up. On February 29th, attorneys from the 3 law firms that are representing the Sitzer Burnett plaintiffs, and then they go on to name the attorneys, filed a motion in the U.S. District Court in Western Missouri for attorneys' fees and costs on behalf of their firms and the 8 law firms that are representing the Morrell case. So these are 2 distinct cases. So you have Sitzer Burnett and Morrell. That's what's being adjudicated here. And then they go on to name all of the firms that were implicated in that particular suit. According to the motion, the law firms have been working on a contingency basis for more than 5 years, racking up a combined 96,500 hours of labor. They've been working hard, folks, adding up to more than $80 million of the firms. Adding up to more than $80 million if the firms had been charging their usually hourly rates. Now, you may be wondering, what's their hourly rate? Well, if you do the math on it, which I did before we hit record, it's 800. Give you the exact number real quick. I think it's 831. Where's my calculator? 829. So $830 per hour. How do they do it for so cheap? Let's continue. They're asking for a third of the combined $208 million settlement fund. So essentially they're asking for $70 million plus the reimbursement for the out-of-pocket, which comes out to $82 million. So roughly 40% of the total settlement funds. Now understand the numbers can go up or down. I understand how math works, depending on what the settlement is per se. So had they gotten a larger settlement, then these numbers would be higher, or at least the hour return on investment per hour would be higher. The percentage of the total funds might be lower. All right, so they did so despite this case having no roadmap anyway. So they're essentially saying that, well, yeah, they did so despite this case having no roadmap or pre-established path to a recovery. So they're essentially introducing a novel concept according to them. Indeed, far from any guarantee that they would be paid for their work or reimbursement in their expenses. Chief counsel faced off against well-funded and entrenched opponents represented by at least 20 of the top defense firms in the country. Oh, David versus Goliath, huh? This is going to get me riled up. Good thing I have an appointment here in about 10 minutes, so I have to wrap this up quickly. Well, the reason that there's so many top firms out there is because you sued everybody under the sun, right? So you have all these brokerages out there that you continue to bring suit. You named as many people as you possibly could, right? So you had those 5 brokerages. The moment that, or the 4 brokerages plus NAR, the moment that you went out and won that particular case, within minutes you filed in the next case, which implicated Compass, EXP, Redfin, everybody else, right? So this whole notion like David versus Goliath, get out of here. That's just so dumb. So that's one. So we'll start there. Well-funded. Well, let's talk about that well-funded. They actually had to pay out of pocket for their defense. They're not, those individuals have to pay their attorneys, not on a contingency basis. They're paying their bills. They're paying up front. They're paying the retainer fee. And then every hour and every month they have an invoice, right? So this whole notion of well-funded, all the entrenched opponents, get out of here with that mess. Anyway, Sitzer Burnett went to trial in October 31st, in a historic verdict. A jury found that Keller Williams, RE/MAX, Anywhere, and NAR, and the Home Services of America, we just talked about that, conspired to inflate broker commission rates paid by home sellers. The jury awarded $1.78 billion in damages and awarded, which is going to award it basically to 500,000 Missouri homeowners. So as a quick recap there, we just talked about it. There's 3 brokerages that have settled. This is where that number is coming from, that $200+ million worth of settlement. That's where they're getting their $82 million, or are seeking that $82 million in reimbursement. So this goes on to explain that. Anywhere and RE/MAX settled for the Sitzer Burnett trial for $83 million and $55 million respectively. Keller Williams settled February 1st to the tune of $70 million. So that's where that number came from, that they're seeking almost 40% of that amount. That was time and money spent. The motion also stressed that the law firm's work on Sitzer Burnett and Morrell prevented them from taking on other work. Come on now. That was time and money spent and invested on behalf of the settlement class that could have been spent on a less risky case. That's a business decision. You got into this business, so don't go out here saying, oh, well, I could have been doing something else. I was investing. I invested all this money in buying used limos. Well, I could have been doing this and selling new Tundras. I don't know. It's early, but essentially it's a business decision for you. So this whole notion of we could have been doing something else. Yeah, then go do something else. If you obviously saw that the return was going to be high enough. So there's a business decision for you. So nobody's anyway. Keller Williams would have never come to the table without the threat of the trial looming. And that obviously correct belief in RE/MAX and Anywhere that things weren't going too well. They never would have settled. It's because you have law firms that are willing to set up and put the time and money and resources behind this to hold companies like this accountable. And that's the reality of it. No, the reality of it is you're looking for a paycheck. Now, if you wanted to really hold these companies accountable as well, then do it for free. There's pro bono work, right? If you really want to do this, if you wanted to hold these company accountable, or nobody wants to work for free, unlike you're trying to get agents to work for free, basically. But let's talk about this. Maybe at a reduced fee. When we're going to get to a point that is really telling here in a couple of seconds. According to Ketchmark, I guess that's how you say it, the attorney's motion pertains solely to the amounts the law firms are asking for in regard to the 3 proposed settlements. They go on to say that basically once more people settle, once we win, we're going to get more. This is not our entire compensation. So understand that the money that they've already invested, they might incur some additional cost, but as far as the huge payouts, they're still coming. This is not the beginning and end. This is just the beginning. Some in the real estate industry have objected to the law firms asking for a customary fee. This is where we get into it, right? So when they were suing NAR and franchisers for allegedly stabilizing commissions at a 2.5% and 3%. But there's zero comparison between the two, said the attorney. There's a difference between a fee application where the court comes in and reviews the amount and approves an amount and conspiring with your competitors to set your wages. So what is the difference? You can say that there's zero comparison all you want, but if you're looking at a customary fee, if you're relating whatever you're charging 30% plus all the expenses to where it gets to 40% of the settlement, you're saying that's a customary fee, when the real estate agents were saying that there's a fee that is still negotiable from their home sellers, is still negotiable from all of their clients. What's the difference? Well, there is one main difference, because as opposed to real estate agent commissions being negotiable, because that's still that is still a thing, that has always been a thing, regardless of what this verdict says. Let's go to the other side of the equation. Let's go to your class action suit. Can your 500,000 residents, can they negotiate your fee? You're taking a third, you're asking the court for a third, right? Well, can your individual constituents, as opposed to one singular entity, can your 500 people that you represent, that half of them are never going to claim this judgment, those individuals, can they negotiate how much you get? Can they say, well, you know what, I don't like this 30% that you're getting. Let's do 5%, and then you can name me on the suit. Can they do that? No, of course the answer is no, right? So you're right that you're right in one respect that they're not the same, but as far as zero comparison, there's a lot more comparisons that you would care to mention. But if you're looking at who has the most latitude, who has the most flexibility, it's actually the clients that the real estate agents represent, not the people that you are working on a contingency base. Actually, I shouldn't say that, because it is contingency based. That's how you been sending out mailers, sending out emails. Hey, if you sold a house from from this time frame to that time frame, you're entitled to X, Y, and Z. And then they go on to explain what it could potentially be for the plaintiffs that end up winning. So if you will not end up winning, what the payouts could ultimately be is what you're seeing on the screen right now. But anyway, I have an appointment that I need to get to, thankfully, because I could ramble on for a while. Let me know what you think. Is this just? Should they have done 20%? Should they have done 40%? Should they have done 80% in fees for their clients? Let me know in the comment section down below. I'll see you tomorrow.